long day, because this afternoon you will have that privilege of having with you no less than Justice Bitog himself, who will give a special lecture in civil law. Be sure not to miss that opportunity. I said that is a rare privilege coming from the authority himself in civil law. That could help you a lot in civil law. Okay? So be guided by that. So let us continue now. The last topic that we covered last night was freedom of expression. Let us now consider freedom of religion. Another preferred right, just like freedom of expression. This is a preferred right. According to the Supreme Court in Ebralinag, religious freedom is a fundamental right which is entitled to the highest priority and the amplest protection among human rights, for it involves the relationship of man to his Creator. Do not forget that one. This is a fundamental right which is entitled to the highest priority and the amplest protection among human rights, for it involves the relationship of man to his Creator. Now, first of all, what are the relevant constitutional provisions to consider when we talk of freedom of religion? You have to remember, first of all, Section 5 of the Bill of Rights. Under Section 5, if you look at your Constitution, the first sentence there is known as the Non-Establishment Clause. No law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. The Non-Establishment Clause. The second sentence is known as the Free Exercise of Religious Profession and Worship Clause. The provision states that the free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. The free exercise of religious profession and worship clause. And the third sentence there is known as the No Religious Test Clause. No religious test shall be required for the exercise of civil or political rights. These are the three important clauses there in Section 5. The Non-Establishment Clause in the first sentence, the free exercise of religious profession and worship clause in the second sentence, and the no religious test clause in the third sentence. Now take note, however, that all of these will have to be considered in view of Section 6 of Article 2. A very important principle, the separation of church and state doctrine. It is there. The separation of church and state shall be inviolable. So this provision under Section 5 of the Bill of Rights must be taken or must be viewed within the context of the separation of church and state doctrine under Section 6 of Article 2. Remember that our adherence to the separation of church and state doctrine now was because of what happened before. Before, instead of the doctrine of separation of church and state, you have the union of the church and state doctrine, especially during the Spanish periods. And you know very well, because of that union of church and state doctrine, the church became very powerful. The friars became very powerful. Not only in the Philippines, but even in other countries in Europe. They became very powerful. So that led to abuses, corruption. Okay? So because of that, and as a reaction to that, beginning with the 1935 Constitution, we veered away from the union of church and state doctrine. Instead, we now adhere to the separation of church and state doctrine. Now also, you have to consider Section 29, Paragraph 2 of Article 6. I hope you still remember that provision. Since we adhere to the doctrine of separation of church and state, as well as under Section 5, the non-establishment clause, so it follows therefore under Section 29, Paragraph 2 of Article 6 that no public money or property shall be appropriated, applied, paid, or employed directly or indirectly for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion, or of any priest, preacher, minister, or other religious teacher or dignitary as such, except when such priest, preacher, minister, or dignitary is assigned to the armed forces or to any penal institution or government orphanage or leprosarium. These are the 4 exceptions. General rule, because of the non-establishment clause and the doctrine of separation of church and state, no public money or property shall be appropriated, applied, paid, or employed directly or indirectly for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion, or of any priest, preacher, minister, or other religious teacher or dignitary as such. What are the 4 exceptions? Except when such priest, preacher, minister, or dignitary is assigned to the armed forces or to any penal institution or government orphanage or leprosarium. Be mindful of these 4 exceptions. That's why, as you must have noticed that one, in the armed forces we have chaplains there. Pinasusueldo ng gobyerno yan. And so with doon sa National Penitentiary sa Muntinlupa, meron ding chaplain yan. That is because of the exception. And also in connection with that, with freedom of religion, do not forget also, should religious instructions be allowed in public elementary and secondary schools during regular class hours? Should that be allowed? Religious instructions in public elementary, secondary schools during regular class hours. Should that be allowed? You better consider Section 3. Section 3, Paragraph 3, Article 14. That was asked 3 years ago in the bar. That is the relevant provision to consider. It may be allowed for as long as there are 3 important requisites. What are those? There must be an option expressed in writing by the parents or guardians of the children or wards. Second, the instructor shall be designated or approved by the religious authorities of the religion to which the children or wards belong. And finally, there shall be no additional cost to the government. These are the conditions or the requisites before religious instructions may be allowed in public elementary and secondary schools during regular class hours. Section 3, Paragraph 3, Article 14. Do not forget that one, kasi that was, as I told you, that was asked in the bar about 3 years ago, 2006, if I remember right. First, for it to be allowed, there must be an option expressed in writing by the parents or guardians of the children or wards. Second, the instructor should be designated or approved by the religious authorities of the religion to which the children or wards belong. Third, no additional cost to the government. So these are the 3 important, these are the provisions, constitutional provisions that ought to be considered when we talk of freedom of religion. What provisions? Section 5 of Article 3, then Section 6 of Article 2, the doctrine of separation of church and state, and then Section 29, Paragraph 2 of Article 6, where no public funds, property may be used, applied for the support of any religion or of any priest except, yung apat na exceptions, and finally, in the matter of allowing the teaching of religion in public elementary and secondary schools during regular class hours, Section 3, Paragraph 3 of Article 14 of the Constitution. Okay? So be guided by those. Now remember that, as I told you, freedom of religion is a fundamental right which is entitled to the highest priority and the amplest protection among human rights, for it involves the relationship of man to his Creator. And because of that, what is the sole justification for a prior restraint or limitation on the exercise of religious freedom? That was explained in Ebralinag. Anong sabi ng Supreme Court? I hope you still remember the Ebralinag case. Ebralinag versus the Division Superintendent of the Schools of Cebu. The case involving the expulsion of members of the Children of Jehovah's Witnesses who refused to salute the flag during flag ceremonies. Hindi pwede yun. Yung ginawa, expelling them. Initially in Hirona, sabi ng Supreme Court, pwede yun. But in Ebralinag, the Hirona ruling was abandoned. So sabi ng Supreme Court, citing German versus Barangan, the sole justification for a prior restraint or limitation on the exercise of religious freedom is the existence of a grave and present danger of a character both grave and imminent, of a serious evil to public safety, public morals, public health, or any other legitimate public interest that the state has a right and duty to prevent. That is the sole justification for a prior restraint or limitation on the exercise of religious freedom. I repeat, what is that justification? The existence of a grave and present danger of a character both grave and imminent, of a serious evil to public safety, public morals, public health, or any other legitimate public interest that the state has a right and duty to prevent. That is the sole justification for a prior restraint or limitation on the exercise of religious freedom. Since this is a preferred right, a fundamental right which is entitled to the highest priority and the amplest protection among human rights, for it involves the relationship of man to his Creator. Do not forget that one. Now, also you have to remember the two aspects of freedom of religion. What are the two aspects? What are the two aspects of freedom of religion? Presence of mind. Hindi pa nagising to mga to. Natutulog pa to. What are the two aspects of freedom of religion? Freedom to believe. And what is the other one? Freedom to act on one's belief. These are the two aspects of freedom of religion. Freedom to believe, freedom to act on one's belief. Freedom to believe is absolute and may not be interfered with by the state, for as long as the belief is confined within the realm of thought of the believer. Absolute yan. Hindi pwedeng panghimasukan ng Estado. Hindi pwedeng pakialaman ng gobyerno. For as long as the belief is confined within the realm of thought of the believer. However, the other aspect, freedom to act on one's belief, ibang usapan yan. Once the believer begins to externalize on his belief, so that it will now affect public peace, public morals, public safety, public welfare, makikialam na yung gobyerno, usually under the police power. So, freedom to act on one's belief is not absolute. What is absolute is freedom to believe. Freedom to believe, I repeat, is absolute and it may not be interfered with by the state under any guise, under any pretense. But freedom to act on one's belief is not. It is subject to regulation. The moment the believer begins to externalize on his belief, and that will now affect public peace, public morals, public safety, or public welfare, makikialam na yung gobyerno dyan, usually what? Police power. To illustrate, for example, sabing ganon, Mr. Emero isang tao dyan, he believes in Satan as his God. Si Satanas. Pwede ba makialam ang gobyerno sabihin, oy, wag kang maniwala, si Satanas yan, demonyo yan. Anong pakialam mo? I-trip niya si Satanas, di ba? For as long as a belief is confined within the realm of thought of the believer, the state may not intrude into that. That is absolute. However, the moment the believer begins to externalize his belief, like in that case, let us say, because of his belief in Satan, kumuha na siya ng mga infants or virgins to be sacrificed before the altar of Satan. Ibang usapan na yan, he is now acting on his belief, papasok na, makikialam na yung gobyerno, usually in the name of police power. For the promotion of public safety, public morals, the general welfare. So that's it. Do not forget those. So let us consider some of the interesting cases in freedom of religion. I hope you still remember that case of Iglesia ni Cristo versus Court of Appeals. You know what happened there? Remember that the Iglesia ni Cristo maintains a regular TV program. You know that very well. Huh? It maintains a regular TV program. Now, of course, you know very well also the MTRCB, Movie and Television Review Classification Board. All movies, TV shows, including commercials, before they can be shown to the public, dadaan mo na yan sa MTRCB for review and classification. Yung MTRCB that used to be called the Board of Censors. You have such upright people there, honorable people, who impose their branch of morality in all of us, di ba? It is as if we are all children who don't know how to distinguish between good and evil, di ba? Ayan. Kaya ito yung mga upright people, decent people. They have their own concept of morality and that they want to impose that on us all. So they review, kaya mga censors, kaya galit na galit si Justice Sagani Cruz sa mga yan. The most despicable work, according to him, to be a member of the Board of Censors. So are you imposing your brand of morality in all of us? Ano tingin mo sa amin? Mga bata, mga paslit, walang isip, no capacity to discern what is right and what is wrong, what is good, what is evil. Anyway, that's the reality. So there is the MTRCB. An anachronism in a democratic regime. Anyway, so all movies, TV shows, including commercials, before they can be shown to the public, kailangan dadaan muna sa MTRCB for review and classification. So you have now this pre-tape TV program of the Iglesia ni Cristo. Upon review by the MTRCB, napanood ng MTRCB upon review that it was attacking another religion, the dominant one at that. And because of that, anong ginawa ng MTRCB? Anong rating binigay? Oy, rated X. Imagine a religious program, bigyan mo rating rated X. Ano yan? In the Philippines, pag sinabi mong rated X, ano yan? Oy, patikim ng pinya. Di ba ganun yan? Abay natural, magagalit yung iglesia. Imagine, religious program, bigyan mo rated X. Can it still be shown to the public? In the first place, rated X, iba yung connotation sa atin yan, sa culture natin eh. So, because of that, the Iglesia ni Cristo filed that petition, which eventually reached the Supreme Court. The first contention of the Iglesia ni Cristo was that, according to it, its religious freedom is per se beyond review by the MTRCB. That was the first issue there. Now, is that correct? Did the court agree with the Iglesia that this religious freedom is per se beyond review by the MTRCB? Sabi ng Supreme Court that is not correct. That is not correct. The Iglesia ni Cristo postulate that this religious freedom is per se beyond review by the MTRCB, that should be rejected. Its public broadcast on television of its religious programs brings it out of the bosom of internal belief. Television is a medium that reaches even the eyes and ears of children. The exercise of religious freedom can be regulated by the state when it will bring about the clear and present danger of a substantive evil which the state is duty-bound to prevent or suppress, like serious detriment to the more overriding interest of public health, public morals, or public welfare. So with those pronouncements, in effect, ano ang sinabi ng Supreme Court? Try to analyze. Its public broadcast on television of its religious programs brings it out of the bosom of internal belief. Why don't you analyze that statement? In other words, what was the court trying to say here? Your contention that your religious freedom is per se beyond review by the MTRCB, that is not correct. Remember the two aspects of freedom of religion: freedom to believe, freedom to act on one's belief. Freedom to believe, absolute yan. Hindi pwedeng pakialaman yan. But freedom to act on one's belief is different. You are now acting on your belief. Your public broadcast on television of these religious programs brings it out of the bosom of internal belief. You are now acting on your belief. Television is a medium that reaches even the eyes and ears of children. The exercise of religious freedom can be regulated by the state when it will bring about the clear and present danger of a substantive evil which the state is duty-bound to prevent, such as serious detriment to the more overriding interest of public health, public morals, or public welfare. And then the court went further. According to the Supreme Court, a laissez-faire policy on the exercise of religion. You know the laissez-faire policy. Huh? Let alone policy, laissez-faire policy. A let alone policy on the exercise of religion can be seductive to the liberal mind, but history counsels the court against its blind adoption, as religion is and continues to be a volatile area of concern in our society today. We cannot afford to adopt that kind of policy on religious freedom, that let alone policy. It can be seductive to the liberal mind, but remember, history counsels the court against its blind adoption, as religion is and continues to be a volatile area of concern in our society today. For indeed, how many wars have been brought all in the name of religion? Historically, the Crusades during the Middle Ages, the 30 Years' War between the Catholics and the Protestants in Europe, even in the Philippines, How many wars have been brought? All in the name of religion, all in the name of God. Hindi po pwede yan. We cannot allow or we cannot afford to adopt that policy on religious freedom, let alone policy. A laissez-faire policy on the exercise of religion can be seductive to the liberal mind, but history counsels the court. Take note, history counsels the court against its blind adoption, as religion is and continues to be a volatile area of concern in our society today. For sure, according to the Supreme Court, we shall continue to subject any act pinching the space for the free exercise of religion to heightened scrutiny, but we shall not leave its rational exercise to the irrationality of man. For when religion divides and its exercise destroys, the state should not stand still. Take note of that. You have to view that in that context. Because that is true. This is no longer freedom to believe. You are now acting on your belief. Its public broadcast on television of its religious programs brings it out of the bosom of internal belief. That's why I told you, we began with that. What are the two aspects of freedom of religion? Freedom to believe, freedom to actualize belief. Freedom to believe is absolute and may not be interfered with by the state under any pretense, under any guise. But not freedom to actualize belief. Once the believer begins to externalize on his religious beliefs, and that will now affect public peace, public morals, public safety, public welfare, papasok na yung gobyerno. We cannot afford to adopt that laissez-faire attitude on the exercise of religious freedom. That can be seductive to the liberal mind, but history counsels the court against its blind adoption, as religion is and continues to be a volatile area of concern in our society today. For sure, according to the court, we shall continue to subject any act pinching the space for the free exercise of religion to a heightened scrutiny, but we shall not leave its rational exercise to the irrationality of man. For when religion divides and its exercise destroys, the state should not stand still. Okay, be guided by that, That is as to the first contention of the Iglesia ni Cristo. That is, religious freedom is per se beyond review by the MTRCB. That should be rejected. Because what is involved there now is no longer freedom to believe. It is now acting on his religious belief. That is no longer absolute. Now, however, as to the second issue, sabi ng Iglesia ni Cristo, that was grave abuse of discretion on the part of the MTRCB when it gave that rating of rated X to this religious program simply because it attacked another religion. Grave abuse of discretion according to the Iglesia ni Cristo. Ano sabi ng Supreme Court? Indeed, there was grave abuse of discretion on the part of the MTRCB there. Why? In effect, what did the MTRCB do by giving that rating of rated X? What was violated there by the MTRCB? What was violated? You analyze. The MTRCB in effect sided with the other religion. It now violated the non-establishment clause. No law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. Kaya nga in this case, ano sabi ng Supreme Court? The MTRCB may disagree with the criticisms of other religions by the Iglesia ni Cristo, but that gives it no excuse to interdict such criticisms, however unclean they may be. Under our constitutional scheme, it is not the task, it is not the duty of the state to favor any religion by protecting it against an attack by another religion. Do not forget that one. Under our constitutional scheme, it is not the task of the state to favor any religion by protecting it against an attack by another religion. Religious dogma and beliefs are often at war, and to preserve peace among their followers, the Establishment Clause of freedom of religion prohibits the state from leaning towards any religion. So take it from there. Religious dogma and beliefs are often at war, and to preserve peace among their followers, the Establishment Clause of freedom of religion prohibits the state from leaning towards any religion. Vis-a-vis religious differences, the state enjoys no banquet of options. Neutrality alone is its fixed and immovable stance. Vis-a-vis religious differences, the state enjoys no banquet of options. Neutrality alone is its fixed and immovable stance. In fine, according to the court, the MTRCB cannot squelch the speech of the Iglesia ni Cristo simply because it attacks another religion. In a state where there ought to be no difference between the appearance and the reality of freedom of religion, the remedy against bad theology is, the remedy against bad theology is what? Better theology. The bedrock of freedom of religion is freedom of thought, and it is best served by encouraging the marketplace of dueling ideas. When the luxury of time permits, the marketplace of ideas demands that the speech should be met by more speech, for it is the spark of opposite speech, the heat of colliding ideas, that can fan the embers of truth. So there you are. Huh? The MTRCB cannot squelch the speech of the Iglesia ni Cristo simply because it attacks another religion. In a state where there ought to be no difference between the appearance and the reality of freedom of religion, the remedy against bad theology is better theology. The bedrock of freedom of religion is freedom of thought, and it is best served by encouraging the marketplace of dueling ideas. When the luxury of time permits, the marketplace of ideas demands that the speech should be met by more speech, for it is the spark of opposite speech, the heat of colliding ideas, that can fan the embers of truth. So there you are. So what was violated by the MTRCB there is the non-establishment clause, because the MTRCB in effect already sided with the other religion. Hindi pwede yan. Under our constitutional scheme, it is not the task of the state to favor any religion by protecting it against an attack by another religion. Vis-a-vis religious differences, the state enjoys no banquet of options. Neutrality alone is its fixed and immovable stance. So take note of that. In a state where there ought to be no difference between the appearance and the reality of freedom of religion, the remedy against bad theology is better theology. So let them duel in the marketplace of ideas. The marketplace of ideas demands that the speech should be met by moral speech, for it is the spark of opposite speech, the heat of colliding ideas, that can fan the embers of truth. So take it from there. So you have there that interesting case, Iglesia ni Cristo versus Corabiles. Pero as to the first contention of the Iglesia ni Cristo, that is religious freedom is per se beyond review by the MTRCB, that is not correct. That should be rejected. Because what was involved there is no longer freedom to believe. It was now acting on its religious belief. Hindi po pwede yan. We cannot afford to adopt a laissez-faire attitude on the exercise of freedom of religion. That can be seductive to the liberal mind, but history counsels the court against its blind adoption. As religion is and continues to be a volatile area of concern in our society today. Take note of that. Okay? That's one very interesting case. A proper appreciation of the issues there is essential. Now, another interesting case. Ito, matagal ko na inaabangan to pero hindi pa tinatanong hanggang ngayon. Yung Centeno versus Judge Villalon Pornilius. Did you encounter that case? PD 1564. Oy, kayong mahilig mag-solicit dyan, ha? Ang hilig ninyo mag-solicit, ha? Remember, we have PD 1564. What is that? That is the solicitation law. Under PD 1564, remember, if one solicits for charitable and public welfare purpose, one must first secure a permit from the DSWD. Otherwise, that will be a criminal offense. Remember that PD 1564 is a special penal law, malum prohibitum. Sige, maraming guilty. Palagi ko, maraming guilty rito. Ang hilig mag-solicit. Walang permit from the DSWD. Of course, you know the purpose of PD 1564. Why was it promulgated? Why was it enacted? The purpose is to protect the public from fraudulent solicitation. Alam naman niyo yung nangyayari ngayon. Ang dami dyan, solicit ng solicit. Allegedly for charitable and public welfare purpose. Hindi mo alam kung talaga napupunta yan sa charitable or public welfare purpose o napupunta na lang yan sa bulsa ng kung sino-sino dyan. In fact, baka ginagawang racket na yan eh. Hindi ba? So obviously, what was the purpose of PD 1564? What power was exercised there? Obviously, PD 1564 was enacted pursuant to the police power of the state to protect the public from fraudulent solicitation. Lalo na yung tayo mga Pilipino, ha? You know, this one very good trait of Filipinos. And we have to be very positive about this one. Tayo, talagang yung kusang maawain eh. Hindi ba? Pag may nakita ka dyan na nagbibigay yan eh. Magbibigay ka eh. Yan likas sa Pilipino yan. That's a very good trait of us Filipinos. Ang problema, inaabuso yan. Yan ang problema eh. So that's a very good trait of Filipinos. Yung talagang kusang nagbibigay for charity or public welfare purpose. Madali mong hingan eh. Subukin mo sa mga Amerikano or other foreigners. Hihingi ka ng ganyan. Ay, naku, paiyakan yan. Kakasuhan ka pa. Di ba? Hindi sa atin ganun eh. Talagang may that's a very good trait of us Filipinos and we should be proud of that. Ang problema, inaabuso yan. You know that very well. So, that's the purpose of PD 1564. That was a valid police power measure to protect the public from fraudulent solicitation. Ang problema in this case was this. Very interesting. You have this old man. Nag-solicit siya for the repair of his community chapel. Unfortunately for him, kinatok niya yung bahay, yung pinto ng bahay ng judge. Imagine that one. Tinanong siya ngayon ng judge, asan ang permit mo from DSWD? Wala. Ay, patay kang bata. Kinasuhan siya ng judge. Violation of PD 1564. Solicitation without permit from the DSWD. Convicted. Can you imagine such an old man? Senior citizen ka na, makukonvict ka simply because you solicited for the repair of your chapel. Convicted. Can you imagine that one? Senior citizen. So, on appeal to the Supreme Court, what happened? You better appreciate this one. The ruling on appeal to the Supreme Court, judgment of conviction reversed on reasonable doubt. Why was it reversed? Ayan, yun ang importante ngayon. Why was it reversed? Take note, first of all, that PD 1564 is a special penal law. And what is the rule in the interpretation of penal laws? Penal laws are strictly construed against the state and liberally interpreted in favor of the accused. That is a rule in statutory construction. Penal laws are strictly construed against the state. So sabi ng Supreme Court, okay, what is the prohibited act under PD 1564? Always, in dealing with penal laws, lalo na itong special penal laws, first thing to do, determine what is the prohibited act. Since penal laws are strictly construed against the state, what is the prohibited act? The prohibited act under PD 1564 is solicitation for charitable and public welfare purpose without permit from the DSWD. That is the prohibited act. Solicitation for charitable and public welfare purpose without permit from the DSWD. Sabi ng Supreme Court, in this case, what was the solicitation all about? The solicitation was for the repair of the community chapel. What kind of purpose is that? That is a religious purpose. That is part of the propagation of the faith. That is part of evangelization. Now tell me, is a religious purpose the same as charitable and public welfare purpose? Are the two the same? They're not. In the first place, when you solicit for charitable and public welfare purpose, what virtue are you trying to invoke? What virtue? The virtue of charity. On the other hand, when you solicit for religious purpose, what virtue are you trying to invoke? The virtue of faith. Still remember the three basic Christian virtues. Ano yun? Faith, hope, charity. Hindi ba? Incidentally, they are all names of ladies. Si Faith, si Hope, si Charity. Di ba? Hindi sa beer house, ha? Uy, mahilig sa beer house dyan. So, doon pa lang kita mo magkaiba yan eh. The two purposes are different. When you solicit for charitable and public welfare purpose, actually you are invoking the virtue of charity. On the other hand, when you solicit for religious purpose, you are invoking the virtue of faith. When you solicit for religious purpose, what are you trying to arouse in the donor? You are trying to arouse his religious fervor. On the other hand, when you solicit for charitable and public welfare purpose, what are you trying to arouse in the donor? You are trying to arouse his philanthropic spirit. From there around, magkaiba eh. What is the prohibited act under PD 1564? Solicitation for charitable and public welfare purpose. Did that include solicitation for religious purpose? It did not. The two purposes are different. So, kaya nga sabi ng Supreme Court, on reasonable doubt, judgment of conviction reversed. Get the point? In other words, in effect, what was the ruling of the court? In effect, ang sinabi ng Supreme Court was this: do not extend the coverage of PD 1564 to include solicitation for religious purpose. That would be unconstitutional. That would constitute a prior restraint on the exercise of freedom of religion. Remember, under Section 5, ano yung second sentence? The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. So, in effect, if you include religious purpose within the coverage of PD 1564, that will now constitute a violation of the free exercise clause under the second sentence of Section 5 of the Bill of Rights. That will constitute a prior restraint on the exercise of freedom of religion. That will constitute a violation of the free exercise clause. Remember the second sentence of Section 5. The free exercise and enjoyment of religious profession or worship without discrimination for or preference shall forever be allowed. Solicitation for religious purpose, that is part of the propagation of the faith. That is part of evangelization. But be careful, baka again, I caution you again against sweeping generalizations. Baka sabihin nyo, PD 1564 is unconstitutional. That is not correct. The court did not say that one. Ang sinabi ng Supreme Court, do not extend the coverage of PD 1564, especially since that is a penal law, to include solicitation for religious purpose. Yan ang magiging unconstitutional. If you extend the coverage of PD 1564 to include solicitation for religious purpose, obviously that will be unconstitutional. That will violate the free exercise of religious profession and worship clause under Section 5 of the Bill of Rights, the second sentence. That will constitute a prior restraint on the exercise of freedom of religion. But PD 1564 itself enjoys the presumption of constitutionality. It is a valid police power measure designed to promote or to protect the public from fraudulent solicitation. That's why always be careful with the way you present your answer. Do not indulge in sweeping generalizations. Now, actually in this case, Justice Mendoza has a separate concurring opinion. But it's also good to consider his separate concurring opinion. Very interesting. You know, our justices have different insights on issues. Sabi ni Justice Mendoza, very interesting. Sabi niya, in his separate concurring opinion in this case. What is really prohibited? What is really the prohibited act under PD 1564? The prohibited act is solicitation for charitable and public welfare purpose without permit from the DSWD. That is the prohibited act. What is the purpose of PD 1564? PD 1564 was enacted to protect the public from fraudulent solicitation. So obviously it was an exercise by the state of its police power to protect the public from fraudulent solicitation. Sabi ni Justice Mendoza, when one solicits for religious purpose, the chances that the public will be a victim of fraudulent solicitation will be much less compared with when one solicits for charitable and public welfare purpose. Did you get a point? Did you get this point? The chances that the public will be a victim of fraudulent solicitation when one solicits for religious purpose is much less compared with when one solicits for charitable and public welfare purpose. Why? Because when you solicit for religious purpose, kanino ka lang pwede manghingi? Kareliyon mo. Subukin mo, katoliko ka, mag-solicit ka for the repair of the chapel doon sa iglesia. Pagsasarahan ka ng pinto. And vice versa, ganun din. Worse, subukin mo, mag-solicit ka for the repair of the chapel. Abu Sayyaf. Ay, di pugot ulo mo. Di ba? Pero subukin mo mag-solicit sa kanila for the victims of Typhoon Ondoy. Baka umiyak pa yung commander ng Abu Sayyaf. Bigyan ka pa ng part ng ransom money. Hindi ba ganon? When one solicits for religious purpose, the chances that the public will be a victim of fraudulent solicitation is much less compared with when one solicits for charitable and public welfare purpose. Hindi ba? That is true. Besides, sabi ni Justice Mendoza, and this is very interesting, if we extend the coverage of PD 1564 to include solicitation for religious purpose, if we extend the coverage of PD 1564 to include solicitation for religious purpose, sabi niya, then let us prosecute. Let us prosecute all those making Sunday collections in every mass. Lahat yan, walang permit sa DSWD. Hindi ba yung mga pagsimba? O, ano yan? Yan ba may mga permit sa DSWD? Wala. Let us prosecute all of them. Sabi ni Justice Mendoza, what an insight. Sabi ko, ayos din itong insight ni Justice Mendoza. Totoo nga naman yun. We might as well prosecute all of them. They have no permit from the DSWD. A very ridiculous situation. No? So, yun ang, so in other words, take note, do not extend the coverage of PD 1564 to include solicitation for religious purpose. Obviously, that will constitute a prior restraint on the exercise of freedom of religion. That will violate the free exercise and release of religious profession worship clause. The free exercise clause. Now, if you compare the two cases, Iglesia, what was violated by the MTRCB? The non-establishment clause, because in effect, the MTRCB sided with the other religion when it protected it against an attack by the other religion. Pero itong Centeno, what was violated? If you extend the coverage of PD 1564 to include solicitation for religious purpose, ano ma-violate yan? The free exercise of religious profession worship clause under the second sentence. That's why I told you have to analyze Section 5. There are three important clauses there. The first sentence is the non-establishment clause. The second sentence is the free exercise of religious profession worship clause. And the third sentence is the no religious test clause. Allah, sige. They are again making discoveries. Nasa Discovery Channel na naman tayo dyan. Ebralina, ganun din. Free exercise of religious profession worship clause. That case that abandoned the Hirona ruling. What was involved there was also the free exercise of freedom of religion. Ano sabi ng Supreme Court sa Ebralina? Abandoning Hirona? The idea that one may be compelled to salute the flag, sing the national anthem, and recite the patriotic pledge during a flag ceremony on pain of being dismissed from one's job or of being expelled from school, that idea is alien to the conscience of the present generation of Filipinos who cut their teeth on a Bill of Rights which guarantees their rights to free speech and the free exercise of religious profession and worship. So it's there. The free exercise clause was violated also. The idea that one may be compelled to salute the flag, sing the national anthem, and recite the patriotic pledge during a flag ceremony on pain of being dismissed from one's job or of being expelled from school, that idea is alien to the conscience of the present generation of Filipinos who cut their teeth on the Bill of Rights, which guarantees their rights to free speech and the free exercise of religious profession and worship. Remember, religious freedom is a fundamental right which is entitled to the highest priority and the amplest protection among human rights, for it involves the relationship of man to his Creator. And because of that, the sole justification for a prior restraint or limitation on the exercise of freedom of religion is, what is that? The existence of a grave and present danger of a character both grave and imminent, of a serious threat or serious evil to public safety, public morals, public health, or any other legitimate public interest that the state has the right and duty to prevent. Absent such a threat to public safety, the expulsion of the petitioners from the schools where they are enrolled is not justified. So ano violated talaga ron? Free exercise of the religious profession worship clause. You have to view that in that context. Okay. Another interesting case. Itong freedom of religion, very interesting din ito eh. Katulad ito ng freedom of expression. Have you encountered this case? Pastor Junicio Austria versus NLRC. In your labor law, hindi na tackle? Very interesting. Pastor Junicio V. Austria versus NLRC. Pwedeng itanong to sa labor law, pwede rin itanong sa constitutional law. He was a pastor of the Seventh-day Adventist. Yung anong sekta yan? Yung Sabadista. Okay? Seventh-day Adventist. Ito, nag-umpisa ito sa chismis. Yan talagang chismis, pahamak yan eh. Nagsimula to, ang liit na bagay, chismis. Umabot ng Supreme Court. Would you believe that one? Oy. Meddling and prying into the privacy of another. Di ba? Ang nangyari dito kasi, pastor siya ng Seventh-day Adventist, tapos na-chismis doon sa simba, sa congregation nila, na yun daw misis niya, misappropriation of denominational funds. In other words, winaldas yung pera ng simbahan. Misappropriation of denominational funds. Nachichismis yun sa congregation. Natural, protective of the reputation of his wife. Ginawa niya, he confronted the alleged source of the chismis, who happened to be his religious superior. Yun ang source ng chismis, yung religious superior niya. He confronted him. Now, in the course of the confrontation, he simplified the equation. You know what I mean? Sinuntok niya. Dito para wala namang maraming usapan, suntukin na lang, di ba? You simplify the equation. Can you imagine that one? Aber nga, subukin mong suntukin si Cardinal Rosales. What will happen to you, di ba? Sinuntok niya. So, tinanggal siya from the Seventh-day Adventist because of that. Suntukin mo pala naman yung religious superior mo. Now, nung tinanggal siya, he went to the labor arbiter. Nag-file siya ngayon ng illegal termination case against the Seventh-day Adventist. Kita niyo na? Nagsimula sa chismis, umabot sa labor arbiter. Illegal termination case. Ginawa naman ng Seventh-day Adventist, nag-file ng motion to dismiss invoking the doctrine of state immunity from suit. Yan, lumaki na yung sunog, ha? Doon na sa doctrine of separation of church and state, doctrine. So the case had to be elevated to the Supreme Court. From a very minor chismis, umabot sa Supreme Court. Ganyan. So, ang question lang before the Supreme Court is, pwede bang, should that illegal termination case filed by him against the Seventh-day Adventist, should that be dismissed, invoking the doctrine of state immunity from, not the state immunity from, doctrine of separation of church and state? Ayan. I'm sorry. Nabanggit ko yata na state immunity from suit, no? No, I mean, the doctrine of, file ng motion to dismiss yung Seventh-day Adventist, invoking the doctrine of separation of church and state. Yun ngayon ang issue before the Supreme Court. Should that illegal termination case filed against the Seventh-day Adventist, should that be dismissed, invoking the doctrine of separation of church and state? Of course, before the court may resolve that question, naturally, kailangan i-define ng Supreme Court yung tinatawag na purely ecclesiastical affairs of the church. Because if it is found that what is involved really is a purely ecclesiastical affair of the church, hindi pwedeng makialam ang gobyerno dyan. Ha? Hindi pwedeng makialam yung gobyerno dyan. So, in this case, dinefine ng Supreme Court an ecclesiastical affair which the state cannot meddle. So, citing Black's Law Dictionary, sabi ng Supreme Court, an ecclesiastical affair is one that concerns doctrine, creed, or form of worship of the church, or the adoption and enforcement within a religious association of needful laws and regulations for the government of the membership and the power of excluding from such associations those deemed not worthy of membership. So that's how the court defined it, citing Black's Law Dictionary. I repeat, an ecclesiastical affair is one that concerns doctrine, creed, or form of worship of the church, or the adoption of needful laws, adoption and enforcement within a religious association of needful laws and regulations for the government of the membership and a power excluding from such associations those deemed not worthy of membership. Now, based on this definition, sabi ng Supreme Court, based on this definition, an ecclesiastical affair involves the relationship between the church's members and relate to matters of faith, religious doctrines, worship, and governance of the congregation. I repeat, based on that definition, an ecclesiastical affair involves the relationship between the church's members and relate to matters of faith, religious doctrines, worship, and governance of the congregation. To be concrete, sabi ng Supreme Court, to be concrete, examples of the so-called ecclesiastical affairs to which the state cannot meddle are, ano examples? Proceedings for excommunication, ordinations of religious ministers, administration of sacraments, and other activities with attached religious significance. Those are examples of ecclesiastical affairs of the church which may not be interfered with by the state. Ano yun? Excommunication, or rather proceedings for excommunication, ordinations of religious ministers, administration of sacraments, other activities with attached religious significance. Lalo na yung administration of sacraments. Kaya nga, ito example ko nito, halimbawa, magpapabinyag ka ng anak mo. Ano yan? What sacrament is involved there? Baptism. Tapos, tanong na yung pare, ano ipapangalati sa bata? Sagot mo, Pader, gusto ko, anak ko, pangalan mo, Tigre. Hindi papayag yung pare, siyempre ba Tigre? Tapos sagot mo sa pare, bakit Pader sa kapitbahay ko Leon? Pinayagan nyo. Mas gusto ko Tigre, mas matapang. Ayaw ng pare. Because of that, nag-file ka ng petition for mandamus in court to compel the priest to baptize your son Tigre. What do you think? Will your petition for mandamus prosper? What was involved there was a purely ecclesiastical affair of the church, administration of sacrament. Hindi pwede makialam ang gobyerno dyan. Anong mandamos ka dyan? Okay? You get the point? So there you are. Going now to this case. So ano sabi ng Supreme Court in this case? Where what is involved is the relationship of the church as an employer and the minister as an employee, and it has no relation whatsoever with the practice of faith, worship, or doctrines of the church. Meaning to say, the minister was not excommunicated or expelled from the membership of the congregation, but was terminated from employment. That is a purely secular affair. Consequently, the suit may not be dismissed invoking the doctrine of separation of church and state. Get the point? There was a finding by the Supreme Court there that what was involved was the relationship of the church as an employer and the minister as an employee. There was a finding by the Supreme Court there. Where what is involved is the relationship of the church as an employer and the minister as an employee, and it has no relation whatsoever with the practice of faith, worship, or doctrines of the church, meaning to say, the minister was not excommunicated or expelled from the membership of the congregation, but he was terminated from employment. He was terminated from employment. That is a purely secular matter. That is a purely secular affair. Consequently, the suit may not be dismissed invoking the doctrine of separation of church and the state. Okay? So there you are, Pastor Dionisio v. Austria versus NLRC. So those are the more important matters to consider when we talk of freedom of religion. Just remember the provisions, Section 5 of the Bill of Rights, Section 6 of Article 2, Doctrine of Separation of Church and State, Section 29, Paragraph 2 of Article 6, regarding the prohibition against the use of public funds or property for the support of any church or priest, and finally, Section 3, Paragraph 3 of Article 14, with respect to teaching of religion in public elementary and secondary schools during regular class hours. And because of that, do not forget also the two aspects of freedom of religion. What are the two aspects? Freedom to believe, freedom to act as belief. Then in Section 5, remember the three important clauses there. The first sentence is the non-establishment clause. Second sentence is the free exercise of religious profession and worship clause. Third sentence is the no religious test clause. Now, yung Section 6 naman, what rights are those? Tatlo yan, Section 6, liberty of abode, liberty of changing the same abode, and the right to travel. As I told you already, in American case law, yung right to travel, tawag dyan freedom of locomotion, travel, movement. Now, this is a settled area in constitutional law. With respect to the liberty of abode and liberty of changing the same abode, it shall not be impaired except upon lawful order of the court. However, with respect to the right to travel, it shall not also be impaired except in the interest of national security, public safety, or public health as may be provided by law. Itong right to travel among the human rights, in times of emergency, some human rights treaties allow to derogate upon these rights. Lalo na yung right to travel, restricted the movements mo, mga checkpoints, magtatayo. Some human rights treaties. As we were trying to discuss, distinctions between IHL and human rights law. IHL does not permit of any derogation. Pero some human rights treaties allow governments to derogate on certain rights like itong right to travel in times of emergency, public emergency like war. Pwedeng restricted ang movement mo dyan. Even your right against unreasonable searches and seizures may be curtailed. As you know that very well. Settled area ito yung Section 6. It's just a matter of reading the commentaries in your text. The others there, yung Section 10 din, yung non-impairment clause, no law impairing the obligation of contract shall be passed. This is another settled area in constitutional law. Ang importante lang dyan is this. The non-impairment clause always yields to the police power of the state for as long as the subject matter of the contract is imbued with paramount public interest. It always yields to the police power of the state for as long as the subject matter of the contract receive one imbued with paramount public interest. Not only to the police power, it must yield to the power of eminent domain and even the power of taxation for as long as the subject matter of the contract is one imbued with paramount public interest. So settled area na ito That's why if you'll recall that old case, Ichong versus Hernandez, the case involving the then retail trade nationalization law. Ano sabi ng Supreme Court? The police power may not be bargained away through the medium of a treaty or even that of a contract. The police power may not be bargained away through the medium of a treaty or even that of a contract. In fact, into every contract is deemed written the police power of the state. Into every contract is deemed written the police power of the state. So, settled area rin yan. So, yung Section 11, just a matter also of reading that. Free access to the courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. Now, beginning with Section 12, as I told you already, the focus of the Bill of Rights has narrowed. It has now focused on the rights of an accused. Okay, so we shall now shift to the rights of an accused, beginning with Section 12. So let's have a break. I'm sure you have taken this up as well in your criminal procedure as well as in the loan evidence. We have to correlate more often with criminal procedure and the loan evidence when we talk of the rights of an accused. Now, first of all, Section 12. What rights are those? Custodial investigation. Custodial investigation rights of an accused. Now remember, actually, during custodial investigation, strictly speaking, you are not yet an accused. Do not forget that one. During custodial investigation, you are not yet an accused. You are but a suspect. You are not yet an accused since there is yet no case filed against you either in the prosecutor's office or in court. You are but a suspect. And then you were picked up by the police, or sometimes they call it you were invited. Ay ikaw naman nagpaimbita, mahilig magpaimbita. Ibang usapan yan, ibang klaseng imbitasyon yan. That is an invitation which you should learn how to refuse. That's a different kind of invitation. Custodial investigation yan. So anong basis niyan? What is the reason behind this Miranda rights? As decided by the American Supreme Court in Miranda versus Arizona. That's the reason why it was called Miranda rights, because it was derived from that American case, Miranda versus Arizona. Ano ang justification dyan? Anong reason for that, I should say? Sabi ng American Supreme Court, when you are picked up by the police, or sometimes they call it you were invited, you will be brought before a police-dominated atmosphere. You are alone there. You will be faced with seasoned investigators who obviously know their jobs. The atmosphere there can be very intimidating. You are alone. You are at your weakest then. Because I assure you, under those intimidating circumstances, even the assassination of Julius Caesar, you will admit. I assure you that. Ibang usapan yan, You are alone there. You are at your weakest there. You will be brought before a police-dominated atmosphere. You will be faced with seasoned investigators who obviously know their jobs under those intimidating circumstances. Even if you don't know how to sing a song, you will have to sing a song. So, it is there where the Constitution runs to your succor to see to it that if ever you will make any admission or confession there, those are not coerced. That is the reason behind these Miranda rights. So as you can see, because of that, actually, when we talk of the Miranda rights or the custodial investigation rights, it's a whole set of rights. And you have to be very familiar with these rights. What are the rights here? Ilan? Aber nga, binilang ba ninyo yan? O, tingnan nyo, Discovery Channel naman tayo ngayon. Ilan yan? 5 yan. The first, of course, is the right to be informed itself. That is a right. It is incumbent upon the police, the law enforcement officers, that before they question you, they will have to inform you of these rights. The right to be informed, that you have a right to remain silent, that any statement you give may be used in evidence against you. You have the right to be informed that you have the right to have an independent and competent counsel, preferably of your own choice. You'll have to be informed that if you cannot afford the services of counsel, you shall be provided with one. Finally, you'll have to be informed that these rights may be waived by you, but the waiver must be in writing and again in the presence of counsel. Those are the custodial investigation rights. It's a whole set of rights. 5 lahat yan. Pero first and foremost there is the right to be informed itself. And that right to be informed permits the others. Do not forget that one. The right to be informed. That you have a right to remain silent. That any statement you give may be used in evidence against you. Dalawa na yan. You have the right to be informed that you have a right to have an independent and competent counsel, preferably of your own choice. That if you cannot afford the services of counsel, you shall be provided with one. And then you have to be informed that these rights may be waived by you. But a waiver must be in writing and again in the presence of counsel. Yung additional requirement in the presence of counsel, yung that these rights may be waived by you, but the waiver must be in writing and again in the presence of counsel. Yung last requirement, that the waiver must be in the presence of counsel, that is actually our contribution to the Miranda rights. That's not found in the original Miranda vs. Arson case. That is our contribution to the Miranda rights. Make it very difficult on the part of the police and law enforcement officers to extract extrajudicial confession. Di ba? If the police will observe these Miranda rights, practically walang makakuhang extrajudicial confession yan. And because of that, as you know very well, the police had learned how to cope with the problem. Napanood nila yung RoboCop. You are invoking your right to remain silent, we will silence you forever. Di ba? Ganun yan. Di ba? Ganun yan. Simplify the equation. So there you are, First is the right to be informed. That you have the right to remain silent. That any statement you give may be used in evidence against you. Second, that you'll have to be informed. Third na pala, that you have to inform that you have a right to have an independent and competent counsel, preferably of your own choice. Then you will have to be informed that if you cannot afford the services of counsel, you shall be provided with one. And finally, you'll have to be informed that these rights may be waived by you, but a waiver must be in writing and again, in the presence of counsel. A whole set of rights. Now take note. Because of this, first of all, be reminded Section 12, Paragraph 3. Any confession or admission obtained in violation of this or Section 17 thereof shall be inadmissible in evidence against him. Any confession or admission obtained in violation of Section 12 shall be inadmissible in evidence against him. And then you have to consider Section 12, Paragraph 4. The law shall provide for penal and civil sanctions for violations of this section, etc. Now, in connection with that, what law was enacted by Congress? Ay, nako, your criminal law, kinalimutan naman yung special penal law. Republic Act 7438. Ano yung Republic Act 7438? A special penal law, an act defining certain rights of person arrested, detained, or under custodial investigation, etc. That was enacted by Congress pursuant to Section 12, Paragraph 4, which says that the law shall provide for penal and civil sanctions for violations of this section, etc., etc. Because of this, Congress enacted Republic Act 7438. If I were you, yung Section 12, Paragraph 4, lagyan nyo na kagad para you'll always be reminded na mayroon ng implementing law yan. Anong law yun? Republic Act 7438, an act defining certain rights of person arrested, detained, or under custodial investigation, as well as the duties of the arresting, detaining, and investigating officers and providing penalties for violations thereof. A special penal law, malum prohibitum. Baka yan pa yung kalimutan ninyo, ha? Okay? Now, the first among the rights under Section 12 is the right to be informed itself. Now, the kind of information required by Section 12, according to the Supreme Court in several cases, must be a meaningful information conveyed to the suspect in a language or dialect known to and understood by him. So, hindi pwede yung cursory reading of the Bill of Rights. Babasahan mo siya, ay, you have your right to... Anong maintindihan niya riyan? The law enforcement officers, before they are supposed to question you, it is incumbent upon the law enforcement officers to apprise of you of this right, to inform you of these rights. And I repeat, the kind of information required by Section 12 must be a meaningful information conveyed to the suspect in a language or dialect known to or understood by him. Kaya in some of the police precincts here in Manila, usually naka-mimeograph na yan, pro forma na. Di ba? Ikaw ay pinababati namin sa iyo ang iyong mga karapatan sa ilalim sa ligang batas. Hindi pa pwede yon. If you'll follow the rulings of the Supreme Court on the subject, I repeat, the kind of information required by Section 12 of the Bill of Rights must be a meaningful information. So the mechanical act of reading the provisions of the Bill of Rights on him before he's questioned, hindi po pwede yan. That will satisfy the requirement. Meaningful information conveyed to the suspect in a language or dialect known to and understood by him. Okay? That is important. So you'll have to be informed that you have a right to remain silent, that any statement you give may be used in evidence against you. And then you will have to be informed that you have a right to have an independent and competent counsel, preferably of your own choice. Now, take note of the qualities of counsel required by Section 12. Counsel must not only be competent, he must also be independent. The two qualities of counsel required by Section 12. Counsel must not only be competent, he must also be independent. And because of that, a prosecutor, will he qualify to be a counsel to assist the suspect during custodial investigation? Hindi pwede. Hindi ba? Because according to the Supreme Court, the prosecutor, he may be a very competent counsel, but he cannot be considered an independent counsel contemplated by Section 12 because he represents an interest adverse to the accused. He's out to prosecute the accused. So he may be a competent counsel, but he cannot be considered an independent counsel contemplated by Section 12 of the Bill of Rights. By the nature of his function, a prosecutor represents an interest adverse to the accused. He is out to prosecute the accused. What about a POW lawyer? Pwede? Settled na yan ng Supreme Court, People versus Bacor. Citing People versus Oracoy, People versus Bandula. In People versus Oracoy and People versus Bandula, the court held that a POW lawyer can be considered an independent counsel within the contemplation of the Constitution, considering that he is not a special counsel, a public or private prosecutor, or counsel of the police, or a municipal attorney whose interest is admittedly adverse to that of the accused. Thus, the assistance of a POW lawyer satisfies the constitutional requirement of a competent and independent counsel for the accused. Pero prosecutor, hindi pwede yan. Take note of that, that if he will have to be informed also that if he cannot afford the services of a counsel, he shall be provided with one. That these rights may be waived by him, but the waiver must be in writing and again in the presence of counsel. But then you have to remember, these rights, they become operative only if a person is already undergoing custodial investigation. If he is not yet undergoing custodial investigation, these rights are not yet operative. Ang question dyan, when do you consider a person to be undergoing custodial investigation already? Obviously, that is a very difficult question to answer. That will have to be determined on a case-to-case basis. In fact, with respect to that question, the court can only give us a broad standard. When you see undergoing custodial investigation, sabi ng Supreme Court, if the line of questioning, that is a very broad standard. If a line of questioning has ceased to be a general inquiry, but it has now focused on the person as a suspect for the commission of an offense, from that time on, he is now under custodial investigation, so his Miranda rights become operative. That in itself is a very broad standard. If the line of questioning has ceased to be a general inquiry and it has now focused on a person as a suspect for the commission of a crime, from that moment on, he is now undergoing custodial investigation, so that his Miranda rights become operative. Still, I repeat, that is a very broad standard. So obviously, that will have to be determined on the circumstances, based on the circumstances of its case. Yan ang usual problem there. Like for example, you have one case. He was identified by the witness. He was there in a police station together with the others. Alam naman yung typical scene na police station, usually may mga long benches dyan, maraming usyoso dyan, maraming miron. Lalo na kung yung kaso rape, nako, talagang nanlalaki yung mga mata ng mga yan, di ba? So he was among the bystanders in that police station, mga miron. Dumating yung police, dala-dala may kasamang witness to a homicide case. Tapos, nakita siya ng witness. Sabi ng witness, siya po pumatay. He was positively identified right there and then. During the trial of the case, the defense counsel was objecting to the introduction and evidence of that identification made at the police station by that witness. Sabi ng defense counsel, not admissible. Because at that time, he was not assisted by counsel. That was in violation of his Miranda rights. So, question, kung ba yan, admissible ba yung in evidence, yung identification niya by the witness at the police station under those circumstances? Sabi ng Supreme Court, admissible yan. At that moment, he is not yet undergoing custodial investigation. Hindi nga alam ng police, tinuro siya ng suspect. He is not yet undergoing custodial investigation. His Miranda rights do not become operative yet. So admissible yan, yung positive identification under those circumstances. Iba yung halimbawa, undergoing investigation niya, tinuro siya ng ibang usapan niya, walang counsel. But under the circumstances of that case, that's why you have to be very careful. Since he is not yet undergoing custodial investigation, his Miranda rights, they do not become operative yet. So admissible yan in evidence yung his identification by the witness under those circumstances, since at that time he is not yet undergoing custodial investigation. Okay, take note of that. Now, what about confessions given to the mayor? Ingat kayo dyan, ha? In the first place, remember that the mayor has operational supervision and control over the local police forces under the local government code. So he is deemed to be a law enforcement officer contemplated by Section 12. So, yung bang extrajudicial confession given to the mayor, admissible in evidence? Now you have that case of People versus Andan. Do you still remember this case? Rape with homicide case ito, sensational case ito, several days in the tabloids to eh. Tapos na-aresto siya ng mga pulis. Tapos doon na siya sa munisipyo. Pinagpipiestahan na siya ng mga reporters, mga tabloids. Nakita niya ngayon si Mayor. Sabi niya, yun po si Mayor, kausapin ko lang si Mayor. So pinagbigyan naman siya ni Mayor. So doon siya sa opisina ni Mayor, sinara ni Mayor ang pinto, dalawa lang sila. Tapos there, he confessed to the Mayor na indeed siya nga yung responsible for that heinous crime, rape with homicide. Now, during the trial of this case, the defense counsel was objecting to the introduction and evidence of his extrajudicial confession given to the mayor under those circumstances because at that time, he was not assisted by counsel. Sabi, not admissible. That was in violation of his Miranda rights. So, anong sabi ng Supreme Court? People versus Andan. Be careful, ha? While it is true that a municipal mayor has operational supervision and control over the local police and may arguably be deemed a law enforcement officer for purposes of applying Section 12, Paragraph 1 and 3 of Article 3 of the Constitution. However, appellant's confession to the mayor was not made in response to any interrogation by the mayor. In fact, the mayor did not question appellant at all. No police authority ordered appellant to talk to the mayor. It was appellant himself who spontaneously, freely, and voluntarily sought the mayor for a private meeting. The mayor did not know that appellant was going to confess his guilt to him. When appellant talked with the mayor as a confidant and not as a law enforcement officer, his uncounseled confession to him did not violate his constitutional rights. Take note of that, ha? Actually, hindi naman talaga siya kinwestiyon ng mayor. Siya mismo ang nagsabi na, pwede ko bang kausapin si mayor? Oh. It was appellant himself who spontaneously, freely, and voluntarily sought the mayor for a private meeting. The mayor did not know that appellant was going to confess his guilt to him. When appellant talked with the mayor as a confidant and not as a law enforcement officer, his uncounseled confession to him did not violate his constitutional rights. Thus, it has been held that the constitutional procedures on custodial investigation do not apply to spontaneous statements not elicited through questioning by the authorities, but given in an ordinary manner whereby appellant orally admitted having committed the crime. What the Constitution prohibits is the compulsory disclosure of incriminating facts or confessions. The rights under Section 12 are guaranteed to preclude the slightest use of coercion by the state, as would lead the accused to admit something false, not to prevent him from freely and voluntarily telling the truth. Be guided by that, the rights under Section 12 are guaranteed to preclude the slightest use of coercion by the state, as would lead the accused to admit something false, not to prevent him from freely and voluntarily telling the truth. People versus Andan. What about his extrajudicial confessions given to media men in that case? Kasi ganun din eh. Nung mag-confess sa mayor, ginawa ng mayor, binuksan ng mayor yung pinto, pinapasok ngayon ng mga media men, mga reporters. Again, before the media men, he confessed. Siya nga. So, kinwestiyon yun, admissible ba in evidence? Sabi ng Supreme Court in that case, yes. Pero be careful rin kayo rin dyan, ha? Sabi ng Supreme Court, his confessions to the news reporters were given free from any undue influence from the police authorities. The news reporters acted as news reporters when they interviewed appellant. They were not acting under the direction and control of the police. They did not force appellant to grant them an interview and reenact the commission of the crime. In fact, they asked his permission before interviewing him. That being the case, according to the court, his verbal confessions to the newsmen are not covered by Section 12, Paragraph 1 and 3 of Article 3 of the Constitution, therefore admissible in evidence. But be careful, Look at the guarded statements of the court here, The news reporters acted as news reporters when they interviewed the appellant. They were not acting under the direction and control of the police. Because if it can be shown otherwise, ay hindi admissible yan. The news reporters acted as news reporters when they interviewed appellant. They were not acting under the direction and control of the police. They did not force appellant to grant them an interview and reenact the commission of the crime. So admissible yan. People versus undone. But then you have an interesting question because you must have seen this in the TV. More often, medyo napapadalas ito, hindi ba? Yung videotape confessions before sa TV. Videotape confessions. May mga shows ngayon dyan na yung sabi nga nito, diba? Sabi nagko-confess na sila. Admissible ba yan? People versus Endino. Videotape media confessions. Admissible. People versus Endino. Admissible yan, sabi ng Supreme Court. Kaya lang, nag-air ng caution ang Supreme Court before judge to be very careful in admitting those videotape media confessions. Look, caution, warning, sabi ng Supreme Court. Because of the inherent danger in the use of television as a medium for admitting one's guilt and the recurrence of this phenomenon in several cases, it is prudent that trial courts are reminded that extreme caution must be taken in further admitting similar confessions. Extreme caution must be taken in further admitting similar confessions. For in all probability, the police, with the connivance of unscrupulous media practitioners, may attempt to legitimize coerced extrajudicial confessions and place them beyond the exclusionary rule by having an accused admit an offense on television. Such a situation would be detrimental to the guaranteed rights of the accused, thus imperil our criminal justice system. A word of caution then to lower courts, sabi ng Supreme Court, we should never presume that all media confessions described as voluntary have been freely given. This type of confession always remains suspect and therefore should be thoroughly examined and scrutinized. So there you are. Admissible, kaya lang the court caution trial judges. Take note of that. People versus Endino. Because of the inherent danger in the use of television as a medium for admitting one's guilt and the recurrence of this phenomenon in several cases, it is prudent that trial courts are reminded that extreme caution must be taken in further admitting similar confessions. For in all probability, the police, with the connivance of unscrupulous media practitioners, may attempt to legitimize coerced extrajudicial confessions and place them beyond the exclusionary rule by having an accused admit an offense on television. Such a situation would be detrimental to the guaranteed rights of the accused, thus imperil our criminal justice system. A word of caution then to lower courts. A word of caution then to lower courts. We should never presume that all media confessions described as voluntary have been freely given. This type of confession always remains suspect Therefore, should be thoroughly examined and scrutinized. So be guided by this ruling. People versus Endino. Now, in People versus Obrero, it was in that case where the court clarified. People versus Obrero, May 2000. It was in that case where the court clarified that actually, under Section 12, there are two types or two kinds of involuntary or coerced confessions. You better remember this one. The two types of involuntary or coerced confessions under Section 12, People versus Obrero. What are these two? The first is confession alleged to have been obtained through torture or third-degree methods. That is the one contemplated by Section 12, second paragraph of the Bill of Rights. Second one is confession alleged to have been obtained without the benefit of the Miranda warnings. In other words, his Miranda rights were not scrupulously observed. That is the situation contemplated by Section 12, first paragraph of the Bill of Rights. Now, what is the significance of knowing the distinction between the two? Pareho namang extrajudicial confession yan. Now, take note, the significance of knowing the distinction between the two lies in the application of the presumption. It lies in the application of a presumption. According to the Supreme Court in this case of People versus Obrero, if the confession was alleged to have been obtained through torture or third-degree methods, the presumption is that it was voluntarily given. It was voluntarily given. So that the burden of proving that he was subjected to torture or third-degree methods when he executed that extrajudicial confession lies on the part of the accused, lies on the part of the suspect. Because here the police enjoys the presumption of regularity in the performance of their official duties. On the other hand, if the confession was alleged to have been obtained without the benefit of the Miranda warnings, in other words, he was not apprised of his Miranda rights and that his Miranda rights were not scrupulously observed, the presumption is it was psychologically coerced. So that the burden of proving that he was informed, he was properly apprised of his Miranda rights, and that his Miranda rights were properly observed, lies on the part of the prosecution and the law enforcement officers. So magkaiba yung presumption, ha? That is where the significance of knowing the distinction between the two lies. It is in the matter of application of the presumption. Okay, I repeat, People versus Obrero. The two kinds of involuntary or coerced confessions under Section 12 of the Bill of Rights. The first is confession alleged to have been obtained through torture or third-degree methods, contemplated by Section 12, second paragraph of Article 3. The second one is confession alleged to have been obtained without the benefit of the Miranda warnings. Section 12, first paragraph, Article 3. Now, if the confession was alleged to have been obtained through torture or third-degree methods, the presumption is that it was voluntarily given by the accused, so that the burden of proving that he was subjected to torture or third-degree methods when he executed that extrajudicial confession lies on the part of the accused. On the other hand, if the confession was alleged to have been obtained without the benefit of the Miranda warnings, meaning to say he was not apprised of his Miranda rights and that his Miranda rights were not properly observed, the presumption is that it was psychologically coerced. So that the burden of proving that his Miranda rights were properly observed lies on the part of the prosecution and the law enforcement officers. That is very significant. People versus Obrero, May 2000. Okay? Be guided by those. Those are the more important matters to consider when we talk of the custodial investigation rights of an accused under Section 12 of the Bill of Rights. Now, just to repeat, first of all, remember, during custodial investigation, strictly speaking, you are not yet an accused. There is yet no case filed against you either in the prosecutor's office or in court. You are merely a suspect then. Precisely whatever statement you give there during custodial investigation may become the basis for the filing of a criminal complaint against you in court. That's why also, if you will relate this with your criminal procedure, nagsimula sa Rule 110 yan, mayroon bang custodial investigation yan? Wala pa because custodial investigation is done before the filing of the complaint. Your criminal procedure begins with Rule 110. Rule 110 deals with commencement of criminal action. 111 is independent civil actions. 112 is preliminary investigation. Kaya wala yan in custodial investigation, wala sa rules of criminal procedure niya Because custodial investigation takes place before the filing of a complaint in the prosecutor's office. It is only if once the complaint is filed in the prosecutor's office that your criminal procedure commences. The criminal action is commenced. So you have to understand that. So at that stage, custodial investigation, you are not yet an accused. You are but a suspect. Now, so remember, it's a whole set of rights there, lima yan. What are these rights during custodial investigation? First is the right to be informed itself. So that it's incumbent upon the police, upon the law enforcement officers, that before they question you, they will have to inform you of these rights. And the kind of information required by Section 12 must be a meaningful information conveyed to the suspect in a language or dialect known to and understood by him. So hindi po pwede yung mechanical act of reading to you the provisions of the Bill of Rights on the subject. Because the kind of information required by Section 12 must be a meaningful information conveyed to the suspect in a language or dialect known to and understood by him. So that is the first, the right to be informed, that you have the right to remain silent, that any statement you give will have to may be used against you. You'll have to be informed that you have a right to have an independent and competent counsel, preferably of your own choice. You'll have to be informed that if you cannot afford the services of counsel, you shall be provided with one. Finally, you'll have to be informed that these rights may be waived by you, but the waiver must be in writing and again in the presence of counsel. Okay? Be reminded of those. And because of that, what are the two kinds of involuntary or coerced confessions under Section 12? First, confession alleged to have been obtained through torture or third-degree methods, Section 12, second paragraph. Then the other one, confession alleged to have been obtained without the benefit of the Miranda warning, Section 12, first paragraph. With respect to confessions alleged to have been obtained through torture or third-degree methods, the presumption is that it was voluntarily given, so that the burden of proving that he was subjected to torture or third-degree methods lies on the part of the accused. Now, on the other hand, if the confession was alleged to have been obtained without the benefit of the Miranda warnings, the presumption is that it was psychologically coerced, so that the burden of proving that his Miranda rights were properly observed lies on the part of the prosecution as well as the law enforcement officers. People versus Obrero. Okay? Those are the more important matters to consider there. Now, the next right there, Section 13, the right to bail. Medyo pinasadahan natin dati yan. Remember, under Section 13 of the Bill of Rights. As I told you already, the most important phrase to remember there is before conviction. Before conviction. In which case, all persons shall be bailable, except those charged with an offense with imposable penalties, reclusion perpetua, and the evidence of guilt is strong. That's why, before conviction, when is bail a matter of right? When is it a matter of discretion? It is a matter of right if one is charged with an offense with imposable penalties lower than reclusion perpetua. Matter of right yan. On the other hand, bail becomes a matter of discretion if one is charged with an offense with imposable penalties, reclusion perpetua or higher. So in such a case, it becomes mandatory on the part of the court to conduct a hearing. What is the purpose of that hearing? For the court to determine whether the evidence of guilt is strong or not. Now, in connection with that, let us say, kaso niya, punishable by reclusion perpetua or higher. Tapos, petition for bail before conviction, petition for bail. Mandatory yan, the court is mandatorily required to conduct a hearing to determine whether the evidence of guilt is strong or not. O sabi ng judge during the hearing of that petition for bail, oy, piskal, o ano ito? Petition for bail, kaso nito, punishable by reclusion perpetua or higher. What do you say about this petition for bail? Sagot ng piskal, no objection, Your Honor. Or, I leave it to the sound discretion of this honorable court whether to grant the petition or not. Yun ang sinabi ng piskal. And because of that, the judge granted the petition for bail. Hindi na nag-conduct ng required hearing. Pwede ba yon? Hindi pwede yan, Narciso versus Santa Romana Cruz and other cases. Sabi ng Supreme Court in this case, jurisprudence is replete with decisions compelling judges to conduct the required hearings in bail applications in which the accused stands charged with a capital offense. The absence of objection from the prosecution is never a basis for the grant of bail in such cases. For the judge has no right to presume that the prosecutor knows what he's doing on account of familiarity with the case. That reasoning is tantamount to ceding to the prosecutor the duty of exercising judicial discretion to determine whether the guilt of the accused is strong. Judicial discretion is the domain of the judge before whom the petition for provisional liberty will be decided. The mandated duty to exercise discretion has never been reposed upon the prosecutor. Take note of that. The mandated duty to exercise discretion in such a case has never been reposed upon the prosecutor. Imposed in Bailon versus Season was this mandatory duty to conduct a hearing despite the prosecution's refusal to adduce evidence in opposition to the application to grant and fix bail. Be guided by that, Imposed in Bailon versus Season was this mandatory duty to conduct a hearing despite the prosecution's refusal to adduce evidence in opposition to the application to grant and fix bail. Narciso versus Santa Romana Cruz. Now, a development in this area is the case of Lavides versus Court of Appeals. Ito, ingatan nyo ito, Lavides versus Court of Appeals. Kaso niya, violation of Republic Act 7610. Ano yon? Child abuse law. Now, in his petition for bail, sabi ng judge, marunong ang judge dito wise and judge dito sige, I will grant your petition for bail, but I must arraign you first. Because if I grant your petition for bail without having you arraigned first, paano kung tumakas ka? There can be no trial in absentia. But if I arraign you first and grant your petition for bail, bahala ka. Kung tumakas ka, tutuloyan ko ito. Trial in absentia may take place. Because remember, Section 14, the second sentence there, the last sentence in fact, anong sinasabi dyan? However, after arraignment, trial may proceed notwithstanding the absence of the accused, provided that he has been duly notified and his failure to appear is unjustifiable. Actually, itong last sentence ng Section 14, second paragraph, this is the provision dealing with trial in absentia. Now, as you can see, there can be no trial in absentia if the accused had not yet been arraigned. That is very important. There can be no trial in absentia if the accused has not yet been arraigned. It's there in Section 14, second paragraph, the last sentence. So trial in absentia may only take place if the accused had already been arraigned. So, going back to this case of Lavides versus Court of Appeals, sabi ng judge, I will grant your petition for bail, but I must arraign you first. Because if I grant your petition for bail without having you arraigned first, paano kung tumakas ka? So there can be no trial in absentia. But if I grant your petition for bail after having you arraigned, pwede na yan. Tumakas ka, bahala ka sa buhay mo. Tutuloyan ko itong trial nito. So, as you can see, marunong yung judge wise Yun ngayon ang question, is that condition in an application for bail that accused be arraigned first before he could be granted bail, is that valid? Anong sabi ng Supreme Court in this case of Lavides versus Court of Appeals? Maganda sana yan, sabi ng Supreme Court, kaya lang there is a fly in the ointment. May sabit yan. That condition, hindi pwede yan. Maganda sana yan, pero there is a fly in the ointment. May sabit yan. Why? Because two of the constitutional rights of the accused will be violated by that condition. What rights? First is the right not to be put on trial except upon a valid complaint and information. And second, his right to bail itself. These are two of his rights that will be violated if that condition is allowed. So what rights? First, the right of an accused not to be put on trial except upon a valid complaint or information. Second, his right to bail itself. Now, how is that? Now, with respect to the first, because halimbawa, here was an accused, nakakulong siya, file siya petition for bail. Tapos, siyempre gusto niya makalaya, provisional liberty. Sino ba gustong matulog sa city jail? Especially yung sitwasyon ng city jail natin dito. Many of our city jails, terrible. Siyempre gusto niya makapagpiyansa agad para to gain his provisional liberty. Ngayon, gagawin yan, magpaparin yan. Hindi ba? Kasi pag na-arena siya, pwede siya mag-post ng bail. Question, what kung mayroon talaga siyang valid ground for an motion to quash? Motion to quash, when do you file a motion to quash? Before arraignment nagpa-arraign siya para lang makapag-post bail kagad. Waive na niya yung grounds in a motion to quash. Dim waive na yun. Paano kung talaga may genuine, may real ground siya for a motion to quash like prescription or double jeopardy? Sa kagustuhan yan na makapag-bail kagad, magpaparin yan. Pag nagparin yan, hindi na niya pwedeng may file a motion to quash invoking that. Because the moment nagparin siya, dim waive na yung grounds na yan. Grounds na yan for a motion to quash, you know that one in your criminal procedure. Kaya nga sabi ng Supreme Court, hindi pwede yan. To condition the grant of bail to an accused on his arraignment would be to place him in a position where he has to choose between one, filing a motion to quash, thus delay his release on bail, because until his motion to quash can be resolved, his arraignment cannot be held. Second, foregoing the filing of a motion to quash so that he can be arraigned at once and thereafter be released on bail. These scenarios certainly undermine the accused right not to be put on trial except upon a valid complaint or information and his right to bail. So hindi pwede yan. Maganda sana yan, pero there is a fly in the ointment. May sabit yan, sabi ng Supreme Court, that will violate two rights of an accused. What rights? The right not to be put on trial except upon a valid complaint or information. Second, his right to bail itself. Okay? Yan nga precisely ang purpose for granting bail eh. Reason for granting bail, para masiguro yung attendance niya during the trial. Lavides vs. Court of Appeals. Of course, another significant development here is Mark Jimenez, Government of the USA vs. Judge Porganan, where the court ruled that no bail rule applies in extradition. Kaya lang, as I told you, later on na bago yan. Government of Hong Kong versus Judge Olalia, where instead of the no bail rule, he may be allowed to post bail. But the two conditions should be satisfied before his application for bail be granted. What are those two conditions? First, that once granted bail, he will not be a flight risk or a danger to the community, and that there exists special humanitarian and compelling circumstances that will justify the grant to bail to him. And since this is merely an exception, who has the burden of proving these two requirements? The accused. By what kind of evidence? By a new standard of evidence, a clear and convincing evidence. An evidence which is lower than proof beyond reasonable doubt required in a criminal case, but higher than preponderance of evidence required in a civil case. A new standard of evidence, the clear and convincing evidence. We have taken it up already, be guided by those. Let us now consider Section 14. What are the rights? What rights are those? Section 14. Those are the rights of an accused during trial. Section 14 are the rights of an accused during trial. Yung first paragraph is criminal due process. No person shall be held to answer for a criminal offense without due process of law, as distinguished from due process in general under Section 1. Ito, criminal due process, the first paragraph, Section 14. No person shall be held to answer for a criminal offense without due process of law. Yung second paragraph, you have there the enumeration of the rights of an accused during trial, as distinguished from the rights during custodial investigation under Section 12. Do not confuse the rights under Section 12 from the rights during trial under the second paragraph of Section 14. As I told you already, in Section 12, you are not yet an accused. You are but a suspect. In Section 14, you are now an accused. In fact, your case is already being tried or is about to be tried. Those are the rights during trial. Magkaiba yan. Now, actually, under Section 14, second paragraph, ilan lahat yan? Aber? Again, that is the whole set of rights. Ilan yan? Hoy, Discovery Channel. Ayaw kasing basahin ng kodal eh. Ilan? Ilan ang bilang nyo? Anong 6? Sigurista naman masyado itong isang to. 8 yan. Let us enumerate, identify them first. The first is the right to be presumed innocent until the contrary is proved. Yung presumption of innocence. The second is the right to be heard by himself and counsel. Dalawa na. Pangatlo, the right to be informed of the nature and cause of the accusation against him. Tatlo na. Yung pangapat, tatlo yan. Hindi lang isa yan. The right to speedy trial, the right to impartial trial, the right to public trial. Panlima, the right, pangpito na, the right to confront at to meet the witnesses face to face. By the way, itong pampito na ito, the right to meet the witnesses face to face, in American case law, ang tawag dyan, the confrontation clause. Because in American Constitution, nakalagay doon, the right of the accused to confront the witnesses face to face. That's why in American case law, this is referred to as the confrontation clause. Instead of to confront, milder form tayo, di ba? The right of the witnesses, of the accused to meet the witnesses face to face. Hi, you will testify against me. How are you? You are still alive? Ganun yan. To meet. Sa American, the right to confront. Hoy, ikaw bang magtestigo against me? Mas matapang yun, di ba? And then finally, the right to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. So again, this is a whole set of rights. 8 all in all. Yung second sentence naman, as I already pointed out, that is the provision dealing with trial in absentia. Okay? So that trial in absentia may only take place after the accused had already been arraigned. Now let us focus on some of these rights during trial. Of course, the first and foremost there is the right to be presumed innocent, the presumption of innocence. That's why in your criminal procedure, in the order of trial, who presents evidence first? Why? Because the accused enjoys the presumption of innocence. The prosecutor must overcome that presumption. Hindi ba? By what kind of evidence? A very high kind of proof. Proof beyond reasonable doubt. You see how important is that right, the right to be presumed innocent? But again, correlate with Mark Jimenez's case. This presumption of innocence does not apply in extradition. This applies in a criminal proceeding. In extradition, this does not apply. Why? Because extradition does not involve the determination of the guilt or innocence of an accused. Okay? Kaya order of trial in your criminal procedure, it is always the prosecution who presents evidence first. And remember, the prosecution must rise or fall on the strength of its own evidence. He cannot rely on the weakness of the defense of the evidence for the defense. So that even if the evidence for the defense is weak, but if the evidence for the prosecution is weaker, the accused deserves to be acquitted. That is very important in criminal procedure. In a criminal case, the prosecution must rise or fall on the strength of his own evidence, and he cannot rely on the strength of on the weakness of the evidence for the defense. So that even if the evidence for the defense is weak, but if the evidence for the prosecution is weaker, the accused deserves to be acquitted. Okay? Then the second right there is the right to be heard by himself and counsel, as distinguished from the right to counsel under Section 12. Because actually, in Section 12, counsel will not speak for the accused. He will advise the accused. Samantalang Section 14, he speaks for the accused. It says the right to be heard by himself and counsel. Okay? Pangatlo, the right to be informed of the nature and cause of the accusation against him. Now, when is he informed of the cause and accusation against him? When? During arraignment. That's why arraignment is a very critical stage, an important stage in a criminal proceeding. This is not an idle ceremony. Such a very important right of an accused is involved during arraignment. What right? The right to be informed of the nature and cause of the accusation against him. That's why, for example, if the accused was tried, convicted, but he was not informed of his right, or he was not arraigned, what happens to the entire proceeding? If the accused was tried and convicted without having been arraigned, what happens to the entire proceeding? Yes, the entire proceeding is a complete nullity, as it was conducted in violation of his right to be informed of the nature and cause of the accusation against him. That will be a ground for a grant of new trial on him. Okay? Now, not only that, you know how important arraignment is, because yung trial in absentia nakatali sa arraignment. That's why arraignment in a criminal proceeding, that is not an idle ceremony, nakatali dyan pati yung trial in absentia. There can be no trial in absentia if the accused has not been arraigned. So this is not an idle ceremony. This is a very important stage in a criminal proceeding. In the first place, arraignment involves such an important right of an accused, the right to be informed of the nature and cause of the accusation against him. Not only that, ang trial in absentia nakatali sa arraignment. Okay? Now, ano pang isang right nakatali sa arraignment? Hoy, tingnan nga natin. What other right nakatali sa arraignment? Oy, naku, your right against, yes, right against double jeopardy. Why? Double jeopardy presupposes that there was a first jeopardy. Because if there was no first jeopardy, there can be no double jeopardy now. What are the requisites for the first jeopardy to attach? Ano siya sabi? There must be a judgment rendered by court of competent jurisdiction which already attained finality after the accused has entered his plea. Now, when does he enter his plea? During arraignment. It says there, after the accused has entered his plea, one of the requisites for the first jeopardy to attach. And then he was acquitted or convicted, or the case against him was dismissed without his consent. But it says, after the accused has entered his plea. In other words, if the accused has never been arraigned, there can be no first jeopardy. And if there is no first jeopardy, there shall likewise be no double jeopardy. Kaya yung arraignment is a very important stage in a criminal proceeding. Involved yan, hindi lang yung right to be informed of the nature and cause of the accusation against him, but as well as trial in absentia, nakatali dyan, tsaka yung right against double jeopardy, nakadepende yan dyan sa arraignment. Okay? And then, by the way, when the death penalty law was still in effect, you better consider this also. Among those enumerated as heinous crimes was, incestuous rape. Di ba? Now, anong sabi ng Supreme Court? In incestuous rape, the relationship between the accused and the victim must be alleged in the information. It must be alleged in information, the relationship. Because if it is not alleged in information, although it was proven during the trial and then he was convicted, you cannot impose on him the death penalty there. Why? Imposing on him the death penalty in such a case will violate his right the right to be informed of the nature and cause of the accusation against him. How is that? Because look, if it was not alleged in the information, although proven during the trial, yung relationship, if it was not alleged in the information but proven during the trial and then he was convicted, the relationship in such a case becomes an ordinary aggravating circumstance which can be mitigated by which can be offset by a mitigating circumstance. Yan ang rason dyan. So there is no way by which you can impose the death penalty there. But if it was alleged in the information, the relationship, and then proven during the trial, and he was convicted of such a heinous crime, the relationship becomes a special aggravating circumstance that will justify now the imposition of the death penalty. Did you get the point, Uy! If it was alleged in information and proven during the trial and he was convicted, the relationship becomes a special aggravating circumstance that will qualify the imposition, justify, I should say, the imposition of the death penalty. But if it was not alleged in information, although proven in the trial, during the trial, and then he was convicted, the relationship becomes an ordinary aggravating circumstance which can be offset by a mitigating circumstance. So that there is no way by which the death penalty may be imposed on him. Imposing on him there the death penalty will constitute a violation of the right to be informed of the nature and cause of the accusation against him. Be guided by that, Ano ang susunod? The right to a speedy trial. Ay, nako, ito madalas. Ang daming sige lang invoke ng right na ito. Administrative case, the proceeding delayed. Rireklamo siya. Sabi niya, violative of my right to speedy trial. Stupid. That is an administrative case. The right to speedy trial is a right that belongs to the accused in a criminal case, and only the accused may invoke that right. If you are not an accused in a criminal case, why are you invoking a right that does not belong to you? Madalas ganon, even sa media ang lalakas na loob. Speedy trial. Anong case? Election case. Teka muna, ba't nag-speedy trial? Hindi naman criminal case yan, The right to speedy trial, remember, is a right that belongs to an accused in a criminal case. Therefore, only the accused may invoke that right. In an administrative case or other proceedings, if the proceeding is unduly delayed, anong right invoke mo? Section 16. Do not confuse Section 16 from the right to speedy trial. Section 16 is the right to speedy disposition of cases. Therefore, all courts, even administrative proceedings. And this is a right that belongs to all persons. That is the proper right to invoke there. Right to speedy disposition of cases before all judicial, quasi-judicial, or administrative bodies. Yung right to speedy trial, remember, is a right of an accused during trial. So only the accused may invoke that. Any other proceeding, or if you happen to be the private prosecutor, and then you feel that the trial is being unduly delayed, anong invoke mo? Not the right to speedy trial, private prosecutor ka Right to speedy disposition of cases under Section 16, which is a right that is available to all persons before all judicial, quasi-judicial, or administrative bodies. That I wish to highlight kasi madalas ko narinig yan, invoke ng right to speedy trial. Hindi naman criminal case, labor case, administrative case. Ano ba naman yan talaga? Sakit sa tainga pag ganun na. Yan ang siya sabing, a little learning is a dangerous thing. You have to know that one. The right to speedy trial, that is a right that belongs to an accused in a criminal case. Therefore, only an accused may invoke that right. Any other proceeding, you feel the proceeding is unduly delayed, the proper right to invoke is Section 16. the right to speedy disposition of cases, which is available to all persons before all judicial, quasi-judicial, or administrative bodies. Ay, nako. Okay? Susunod yan, the right to impartial trial. Ayan. Pag pinag-usapan, the right to impartial trial, ano ang pwedeng pumasok dyan? Yung mga sensational cases, yung mga high-profile cases, madalas kasi sensational yan, tinutukan ng media yan, madalas sasabihin ng akusado, wala na, tried by publicity na kami, convicted na ako. Ayan. Pag sinabi niya yan, what is he trying to invoke? The right to an impartial trial. Kaya ang papasok na principle dyan, pag pinag-usapan ng impartial trial, anong papasok na concept? The question on prejudicial publicity. Kasi madalas ininvoke ng akusado in a sensational case, web case, Estrada versus Digambay, and the others, Tihangki. Sabi, we have already been judged, tried by publicity, convicted na kami, guilty na kami. Whenever they invoke that, what they are invoking is the right to impartial trial. So ang involved dyan is the question on prejudicial publicity. Now, however, with respect to this question, remember that there are two schools of thought here. The British approach, which adopts the possibility of prejudice test, and the American approach, which applies the actual prejudice test. Of course, the Philippines, we follow the American approach. This is a more skeptical approach. So that under this actual prejudice test, to warrant a finding of prejudicial publicity, there must be allegation and proof that the judge was unduly influenced by what were reported in the media about the case. It is not enough that it is alleged that the judge was unduly influenced, but there must be allegation and proof that the judge was actually influenced by what were reported in the media about the case. This is the actual prejudice test, as distinguished from the British approach, which adheres to the possibility of prejudice test. This is a more skeptical approach, the actual prejudice test. I repeat, under this test, to warrant a finding of prejudicial publicity, there must be allegation and proof that the judge was actually influenced by what were reported in the media about the case. Not that he might possibly have been influenced, but that there must be allegation and proof that he was actually influenced. Kaya in many of these high visibility, high profile cases, because you know, if there is really a finding of prejudicial publicity, what will be the effect of that? Kung mayroon talagang finding of prejudicial publicity, what will be the effect of that? That will be a proper ground and a motion for new trial. If it can be shown that there was prejudicial publicity in the case, that could be one ground for the grant of a motion for new trial. So, I repeat, we follow the American approach, the actual prejudice test. So that under this approach, to warrant a finding of prejudicial publicity, there must be allegation and proof. Allegation and proof that the judge was actually affected, actually influenced. Not that he might possibly have been influenced, but that he was actually influenced by what were reported in the media about the case. Kaya maraming yung web versus yung web case, tapos yung Estrada versus Digambay, yung Tihangki case, yung kay Mayor Sanchez, the court did not grant. Sabi ng Supreme Court, There was allegation that the judge was influenced, but there was no proof that he was actually influenced by what were reported in the media about the case. On the contrary, sabi ng Supreme Court, it was the accused who tried to influence the court. Why? Because more than one half of the defense evidence consisted of newspaper clippings on the case. So on the contrary, it was the accused who tried to influence the judge. So the court did not grant. Okay? Oh, ano pa susunod na right yan? The right to a public trial. Again, this is a right that belongs to an accused in a criminal case, and therefore only the accused can invoke this one. Itong this right to a public trial. You have to understand this one. This right to public trial. You know historically how this evolved. This right to a public trial. That's why this is a right that belongs to an accused. How did this evolve? You have to understand this one. In the past, especially during the infamous Inquisition in Europe, where so many suspected witches have been unjustly condemned and burned at the stake, how was trial of criminal cases conducted then? The trial during those times was done in secret. Down there at the dungeon, the accused, nakakadena, nakakulong yan. He's been tried there in secret. Nobody knows what's going on. And the prosecutor is at the same time the judge. And the very evidence that will hang him or her are the ones extracted from his own lips pa. That was how trial of criminal cases were done in the past. And you remember, so many have been unjustly condemned. Because of that, have you seen that movie, Braveheart? How was he tried? Wala naman nakakita eh. Nilabas na lang nung sentensyado na siya. Hindi ba? Anong penalty sa kanya? Cruel, degrading, inhuman punishment. Ano yon? Tawag yun, disembowelment. Naaga po siyang ganun, bubuksan yung katawan niya. Then isa-isa, that's why you have several knives there, different kinds of knives. Isa-isa nilalabas yung internal organs mo hanggang mamatay ka. Ayan, yun ang penalty niya, disembowelment ang tawag doon. That's cruel, degrading, inhuman punishment. But how was he tried? Nag-iisa lang siya, wala man lang nakakita ron eh. Yung prosecutor niya, yun din ang judge niya. That was how trial of criminal cases was done in the past. So walang kalaban-laban ng akusado dyan. So eventually the clamor began that trial of criminal cases be made public. That's how this right to public trial began, how this evolved. So historically, from the very beginning, this is really a right, again, that belongs to an accused. Therefore, only an accused may invoke this right. That's why in this case, request radio TV coverage of the trial ni Sandigambayan of former Estrada. Sino gumawa ng request? KBP, kapisanan ng mga broadcasters ng Pilipinas. Nag-request sila sa Supreme Court that the members of the KBP be allowed to cover the trial live. Radio TV. In-invoke nila in their request yung right to public trial. Sabi ng Supreme Court, speaking through Justice Vitog, tika muna. Huy, this right to public trial, this is a right that belongs to an accused. And therefore, only the accused may invoke this one. Hindi naman kayo akusado rito ha. Bakit kayo nag-invoke ng right that does not belong to you? Sabi ni Justice Vitog, an accused has a right to a public trial, but it is a right that belongs to him more than anyone else, where his life or liberty can be held critically in balance. A public trial aims to ensure that he is fairly dealt with and would not be unjustly condemned, and that his rights are not compromised in secret conclaves of long ago. Ano yun? In dungeons. That was how trial of criminal cases was done in the past. A public trial aims to ensure that he is fairly dealt with and would not be unjustly condemned, and that his rights are not compromised in secret conclaves of long ago. A public trial is not synonymous with publisher's trial. It only implies that the court doors must be open to those who wish to come, sit in the available seats, conduct themselves in decorum, and observe the trial process. So there you are. Do not invoke a right that does not belong to you. You are not the accused here. Why are you invoking the right to public trial? This right to public trial. Again, this is a right that belongs to the accused. Therefore, only the accused may invoke this one. A public trial is not synonymous with publicized trial. Get the point? So, huwag kayo mag-i-invoke ng right that does not belong to you, ha? Then the others there, yung confrontation clause, the right to meet the witnesses face-to-face, and then the right to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. These are the rights of an accused during trial under the second paragraph of Section 14. So, walo yan, ha? Ulitin natin. Una, the right to be presumed innocent until the contrary is proved, and then the right to be heard by himself and counsel, the right to be informed of the nature and cause of the accusation against him, pagkatapos yung tatlo. The right to speedy trial, the right to impartial trial, the right to public trial. Tapos the right to meet the witnesses face-to-face, and the right to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. Kaya lang, mayroon pang isa dyan, Section 17, that is a right, an important right of an accused during trial. Ano yan? The right against self-incrimination. Ito importante rin ito, ha? The right against self-incrimination. This is another very important right of an accused during trial. Besides, as I already clarified, this is also covered by the exclusionary rule in evidence. Because if you read Section 12, third paragraph, admissions, any confession or admission on violation, obtained in violation of Section 17 hereof, shall be inadmissible. Di ba? Another provision governed by the exclusionary rule in evidence. So that any evidence obtained in violation of this, or any admission or confession obtained in violation of Section 17 shall not be admissible. What kind of evidence? Incompetent. It may be very relevant, it may be material, very material, but it is not, it is incompetent. Okay? Now, first of all, ano ba ang reason? How did this evolve? The philosophical underpinning of this right against self-incrimination. Again, you have to understand that so that you can properly appreciate this one. Now, try to visualize, try to imagine in a criminal case. Who are the real protagonists in a criminal case? Tell me. The state and the accused. From the very beginning, the battle is unequal. Hindi ba? Buong estado, nag-iisa yung akusado. The police, the law enforcement officers are officers of the state. The prosecutors are officers of the state. He is alone. He is faced with the awesome machinery of the state. So from the very beginning, hindi patas yung labanan. You know that very well. Tapos, ang masama pa dyan, sabi nga ng Supreme Court, unequal na ngayon laban, Pagkatapos, the very evidence that will hang him are the ones extracted from his own lips pa. That is very unfair already. Too unfair. That's why there evolved the right not to be compelled to testify against oneself. To level the playing field, quote-unquote, more or less. Since that is the situation in a criminal case, for the state to convict the accused, the state must be able to come up with an evidence other than the one taken from his own lips. So there evolved the right not to be compelled to testify against himself. Yan ang philosophical underpinning of that right. Hindi na nga parehas yung laban eh. Here is the accused, he is alone. Kalaban niya the whole machinery of the state. The police are officers of the state. The prosecutors are officers of the state. He is alone. Pagkatapos yung ebidensyang kukunin pa to hang him, yung extracted from his own lips pa. That is too unfair already. So, as I said, to level the playing field, quote-unquote, it is but proper that in a criminal case, if the state would like to convict an accused, the state must be able to come up with an evidence other than the one taken from his own dear lips. So there evolved now the right against self-incrimination. An accused may not be compelled to testify against himself. Get the point? Oy! To understand that. And because of that also, as you can see, this right applies only to testimonial compulsion. This applies only to testimonial compulsion. Kaya nga sabi ng Supreme Court, what is actually prohibited is the use of physical or moral compulsion to extort communication from the accused, not the inclusion of his body in evidence when it may be material. Because this applies only to testimonial compulsion. I repeat, what is actually prohibited is the use of physical or moral compulsion to extort communication from the accused, not the inclusion of his body in evidence when it may be material. For instance, you have that old case, U.S. versus Tanteng. Substance emitted from the body of the accused may be received as evidence in prosecution for acts of lasciviousness. U.S. versus Ong Siu Hong. Morphine forced out of the mouth of the accused may also be used as evidence against him. You still remember itong morphine? Hawak-hawak niya yung morphine. Nakita siya ng pulis. Uhulihin siya ng pulis. Nilulun niya yung morphine. O, pinasuka sa kanya. Yan ang Ong Siu Hong eh. Admissible ba yan? Sabi ng Supreme Court, admissible yan. That did not violate his right against self-incrimination. A woman in an adultery case, can she be compelled to undergo a pregnancy test? Will that not violate the right against self-incrimination? It will not. An accused in a rape case, can he be compelled to undergo blood testing to determine the paternity of the child? Obviously, nanganak yung victim, can he be compelled to undergo blood testing to determine the paternity of the child? Will that not violate his right against self-incrimination? It will not. What is actually prescribed, what is actually prohibited, is the use of physical or moral compulsion to extort communication from the accused, not the inclusion of his evidence, of his body in evidence, when it may be material. An accused in a falsification case, may he be compelled to give a specimen of his signature during the trial. Will that not violate his right against self-incrimination? Yes or no? It will. Ano sabi ng Supreme Court? Writing is not a purely mechanical act. It begins from the intellect. Now, let us, madalas hindi maintindihan yan. Let us compare. Ong Siu Hong, Hawak-hawak niya morphine. Nakita siya ng pulis. Uhulihin siya ng pulis. Nilulun niya yung morphine. Pinasuka sa kanya ng pulis. Admissible in evidence ba yung morphine? Admissible. Did that not violate the right against self-incrimination? It did not. In the first place, what kind of evidence is the morphine? Object evidence. Was he compelled to produce the evidence against him? He was not, kasi the evidence is already in existence independently of him. In fact, hawak-hawak niya eh. Naroon na yung ebidensya. Ang problema, nung makita siya ng police, arrestuin siya, instead of hiding it in his pocket, he hid it in his stomach. Pinasukan sa kanya. Was he compelled to produce the evidence against him? He was not. Because the evidence was already in existence independently of him, I should say. Di ba? Do you get the point? Oh. Besides, what kind of evidence is the morphine? Object evidence yun eh. Right against self-incrimination applies only to testimonial compulsion. Now, falsification case. During the trial, he was compelled to give a specimen of his signature. Sabi ng Supreme Court, hindi pwede. That will violate his right against self-incrimination. Remember that writing is not a purely mechanical act. It involves the use of the intellect. Now, bakit ganon? Look, sabi ng Supreme Court, when he is compelled to give a specimen of his signature, the moment he gets hold of that pen, and then he begins to write, at every stroke of the pen, the evidence is produced. If he is not compelled to give a specimen of signature, there will be no evidence against him. But since he is compelled by the court to give a specimen, once he gets hold of that pen and he begins to write, unti-unti lumalabas yung ebidensya. At every stroke of the pen, lalabas yung ebidensya. Hindi ba? He is compelled to produce the very evidence that will hang him. The case is falsification before he gets hold of that pen and before he begins to write. There is no evidence. But since he is compelled by the court to give a specimen of his signature, the moment he gets hold of that pen and then he begins to write, at every stroke of the pen, the evidence is produced. In effect, he is compelled to produce the very evidence that will hang him. That is a falsification case. Remember that writing is not a purely mechanical act. It involves the use of the intellect. Did you see the difference? So there you are. Huh? So this applies only to testimonial compulsion. Now, may this be invoked in an admissive proceeding? This right against self-incrimination, yes or no? Uy. May this be invoked in an admissive proceeding? Pascual versus Board of Medical Examiners. He was a doctor of medicine. Kinasuhan siya ng medical malpractice. During the proceeding, he was invoking his right against self-incrimination. Sabi, hindi. This is not a criminal proceeding. This is merely an admissive proceeding. You cannot invoke that. Ano sabi ng Supreme Court? Pwede. That may be an admissive proceeding, but it partakes of a criminal nature. That may be an admissive proceeding, but that partakes of a criminal nature. Because if indeed is found guilty of malpractice, tatanggalin, i-revoke ng lisensya niya to practice medicine. That is his bread and butter. So pwede yan. Pascual versus Board of Medical Examiners. This right against self-incrimination may even be invoked in admissive proceedings that partake of a criminal nature. Pascual versus Board of Medical Examiners. May this be invoked during inquiries in aid of legislation? Yes, Bengson versus Senate Blue Ribbon Committee. Because under Section 21 of Article 6, the last sentence there says, the rights of persons appearing in or affected by such inquiries shall be respected. And according to the Supreme Court in Bengson versus Senate Blue Ribbon Committee, among the rights that may be invoked during inquiries in aid of legislation is the right against self-incrimination. This may even be invoked in impeachment proceedings. Okay? Take note of that. Now, pag pumasok yung right against self-incrimination, mayroong papasok na concept dyan. Yung tinatawag na immunity statutes. If an accused is granted some kind of immunity, like for example, nag-agree siya to be a state witness, he will testify against his co-accused in a criminal case. On the condition na ilalaglag yung pangalan niya from the criminal information. That is an immunity statute. He is covered by an immunity statute. He agreed to testify as a state witness against his co-accused in a criminal case. Okay? That is an example of an immunity statute. If an accused is covered by an immunity statute, may he still validly refuse to testify, invoking his right against self-incrimination? Yes or no? No more. That is the very purpose of an immunity statute. You are granted, given some kind of immunity in exchange for your testimony. After all, sabi ng Supreme Court, even if during in the course of his testimony, he may incriminate himself, yet no harm can come upon him anymore. Kaya nga siya binigyan ng immunity. That's why, if the accused is already covered by an immunity statute, he may no longer validly refuse to testify, invoking his right against self-incrimination. That is the very purpose of an immunity statute. You are granted some kind of immunity in exchange to your testimony. Okay? Do not forget that. Kaya lang, pagdating sa immunity statute, there are two types. Matagal na hindi nagtatanong dito sa immunity statutes. Basta pinag-usapan, right against self-incrimination, papasok yung concept ng immunity statute. An accused who is already covered by an immunity statute, he may no longer validly refuse to testify, invoking his right against self-incrimination. Do not forget that one. That is the very purpose of an immunity statute. He is given some kind of immunity in exchange for his testimony. So that even if in the course of his testimony he may incriminate himself, no harm can come upon him anymore. Immune na nga siya eh. That is the very purpose of an immunity statute. However, when we talk of immunity statutes, they are of two types. What are these two? First, the transactional immunity, which is broader in the scope of its protection. The transactional immunity, broader in the scope of its protection. By its grant, a witness can no longer be prosecuted for any offense whatsoever arising out of the act or transaction. That's why it's called transactional immunity. Broader in the scope of its protection. By its grant, a witness can no longer be prosecuted for any crime whatsoever arising out of the act or transaction. In contrast, by the grant of use and derivative use immunity, a witness is only assured that his or her particular testimony and evidence derived from it will not be used against him or her in a subsequent prosecution. But if there are other independent evidences pwedeng gamitin against him or her. So, mas limited ang scope of protection. I repeat, in contrast, by the grant of use and derivative use immunity, a witness is only assured that his or her particular testimony and evidence derived from it will not be used against him or her in a subsequent prosecution. But if there are other independent evidences, pwedeng gamitin against him or her pa. So these are the two types of immunity statutes. Mapa Junior versus Sandiganbayan. Now, itong immunity statutes, the nature of this, is this as bonanza from the government? Should this be strictly construed against the accused? Or should it be liberally interpreted in his favor? The grant of immunity to an accused. Sabi ng Supreme Court, tika muna ha, that is not a bonanza for the government. There is a consideration there. That's why it should not be strictly construed against the accused. Sabi ng Supreme Court, these immunity statutes are not a bonanza from government. Those given the privilege of immunity, they pay the high price for it, the surrender of their precious right to be silent. They pay the high price for it, the surrender of their precious right to be silent. Now look, yung mga binibigyan ng ganyang immunity in exchange for their testimony against their co-accused, nako, that is a very dangerous proposition, especially in highly syndicated crimes like drugs. Subukin mong mag-testify against your co-accused. Yan ang sinasabi literally, hindi ka na sisikatan pa ng araw. Hindi ba? Kaya nga sa Amerika, yung witness protection program nila napakalakas. They even go to the extent of hiding the true identity of the witness. After testifying, nililipat nila ng bahay, pati family, nag-undergo pa ng plastic surgery. Ganon kalakas yung witness protection program nila. Kasi delikado yan eh. You agreed to testify against your co-accused, especially in highly syndicated crimes. Ayan, talagang madidisgrasya ka dyan. Yun ang sinasabi ng Supreme Court in Mapa versus Sandiganbayan. This is not a bonanza from the government. Those given the privilege of immunity, they pay the high price for it, the surrender of their precious right to be silent. Our hierarchy of values demands that the right against self-incrimination and the right to be silent should be accorded great respect and protection. Laws that tend to erode the force of these preeminent rights must necessarily be given a liberal interpretation in favor of the individual. They must be given a liberal interpretation in favor of the individual. The government has a right to solve crimes, but it must do it rightly. So be guided by that. So, itong immunity statutes, they should not be construed strictly against the accused. In fact, they should be given liberal interpretation in favor of the accused. Because remember, those given the privilege of immunity, they pay the high price for it, the surrender of their precious right to be silent. So this is not a bonanza from the government. They pay the high price for it. So they should be given liberal interpretation in favor of the accused. Okay? So there you are. So those are the more significant matters to consider. Yeah? The other areas, it's just a matter, settled naman yan, double due pa din, nasa commentaries in your text eh. And yung ex post facto law, settled na rin yan, yung areas na yan, walang movement, saka yung bill of attainder. So this afternoon I said, you will have with you Justice Vito, a special lecture in civil law. be sure to attend that special lecture. Okay? Thank you. And by the way, my good friend Rene, kailan ba si Rene? Monday? You better attend him also because we tend to complement each other. We can tend to complement each other. Whatever matters that I may have skipped or missed, I'm sure he will be able to cover that one. Okay? So that your preparation will be